Para. The sessions judges and the chief judicial magistrates must also ensure that these directions are followed in letter and spirit by the subordinate court. Commitment to human right and the earning to the ensure that court are user friendly and asset to a modern judicial personality and assessment of judicial performance by a superior much must make note of such commitment of a judicial officer, even though the above direction are issued with specific reference to prosecution under section 138 of the Negotiable Instrument Act, they must be followed in all other cases also where the offence alleged is technical and involve no moral turpitude. Para. Being aggrieved with the other granting a general exemption to the accused from personal appearance before the trial court, the complainant has filed this appeal on 17th November 2008. While granting leave in this matter, a bench of two learned judges referred the instant case to a larger bench, posing the following question for determination. Para. One of the questions which arises for consideration in this special leave petition is as to whether the High Court, in exercise of its jurisdiction under Section 482 and 483 of the Code of the Criminal Procedure and under Article 227 of the Constitution of India, could issue guidelines directing all courts taking cognizance of offences under Section 138 of the Negotiable Instruments Act, inter alia, to invoke the discretion under Section 205 of the Code of Criminal Procedure and only with a further direction that summons under Section 205 shall be issued at the first instance, keeping in view importance of the question involved as also the various decisions of this court, upon which the learned judges of the High Court has placed reliance. In our opinion, we think that this is a matter which should be heard by a larger bench. It is directed accordingly. This is how the present appeal has been placed before this bench. Para. Having heard the learned counsel for the parties, we are convinced that the impugned order is unsustainable. Section 205 of the Code, which clothes the magistrate with the discretion to dispense with the personal appearance of the accused, reads as follows: Magistrate may dispense with personal attendance of accused. Whenever a magistrate issue a summons, he may, if he seem reason so do to dispense with the personal attendance of the accused and permit him to appear by his pleader. But the magistrate inquiring into or trying the case may in his discretion at any stage of proceeding direct or personal attendance of the accused and if necessary enforce such attendance in the manner herein before provided. The section confer a discretion on the court to exempt an accused from personal appearance such time his appearance is considered by the court to be not necessary during the trial. It is manifest from a plain reading of the provision that while considering an application under section 205 of the Code of Magistrate has to bear in mind the nature of the case as also the conduct of the person summoned. He shall examine whether any useful purpose would be served by requiring the personal attendance of the accused, or whether the progress of the trial is likely to be hampered on account of his absence. Therefore, the satisfaction whether or not an accused deserves to be exempted from personal attendance has to be of the magistrate who is the master of this court in so far as the progress of the trial is concerned and none else. Stop.